Hello, today I'm with Michael Higgin, who has now recovered from doing the comic relief triathlon in Green Park, Reading. Michael is a partner of the commercial property team at Field Seymour Parkes. Hello, Michael.
Hello.
Tell me a little bit about how you would expect a dilapidations claim to be dealt with at the end of a lease.
The landlord wants the tenant to hand back the property in repair at the end of the term of the lease, and if the tenant doesn't, the landlord will serve a schedule of dilapidations, which is a list of the items of disrepair in the property at that time. That will list the items of disrepair, the provisions of the lease which have not been complied with, and what the landlord expects by way of compensation to put it in the position it would have been had the tenant kept the property in repair.
And those procedures are now set out?
They're fairly well established. There was a new dilapidations protocol published in January 2012, which includes a sample of what a schedule should contain. And that also sets out the recommended procedure for the landlord to follow and the tenant to follow in dealing with a dilapidations claim. It's not a rule to follow that, but it is a recommendation, and if you don't follow it, you could be at risk for costs if the matter goes to trial.
Okay. Now, is the area of law changing at all, or is it very well established?
It's quite well established, but the law is always evolving. There are always cases which shed light on certain aspects. Interesting word, because there was a case earlier this year which was Sun Life Europe and Tiger Aspect Holdings, Tiger Aspect, the TV production company. They'd vacated a property in Soho in 2008, which had been a lease for 35 years. So when it was specified in 1973, it was state-of-the-art, but by the time the lease finished in 2008, it was definitely not state-of-the-art and had not been kept in a good state of repair. So there was a large claim made by the landlord. The interesting point there was whether the tenant was obliged to install new kit to 2008 specifications or merely to hand back in repair the items which had been originally put in. And the judge held that they only had to keep in repair what was originally specified and not to replace the equipment with brand new. Okay.
Now, might the outcome have been different had the building been given back today?
It may well have been. The key point to think about there was statutory compliance, which is an obligation in the lease on the tenant to comply with the laws from time to time. The interesting point here is in air conditioning coolant, where the R22 coolant, which was used in the Soho building with Tiger Aspect, is no longer going to be lawful. So an air conditioning system which runs using that particular coolant may nowadays need to be replaced rather than merely handed back in repair. And that would be an additional cost for the tenant to pay.
So what would you say to a prospective tenant?
A tenant should have a good building survey done when they move into a building to make sure the property is in a good state of repair when they go in. If they're taking a new lease, they should have a schedule of condition attached to the lease limiting their repairing obligation. And if they're taking over an existing lease, like Tiger Aspect did, who acquired this lease in 2000 with only 8 years left to run, take a large reverse premium from the outgoing tenant to compensate you for the repair liability that you're walking into on day one.
Right. You've kindly done a briefing note, Michael. Thank you very much.
That's a pleasure. Thank you.